Hi, I want to tell you about kids. Many people come to me and they say, my kid's going to be 14, my kid's going to be 12, my kid's going to be 16. At what age does he or she get to pick where they live? And I always have to tell them, in Florida, a child never gets to pick where they're going to live. It is one of the factors that's considered under Florida Statute 6113, but there's many other factors. So a child may come to you and he or she may say, look, I just want to spend more time with the other party. It's best to try to work it out. I'm always a believer in trying to settle these issues to work with the child, but sometimes the child's just mad because you're disciplining them, or they don't want to do whatever you're asking them to do, their homework, or they think they're too old now to be with mommy or something like that. And so the Florida legislature has said that it is something that we will consider and the courts will consider it, and perhaps it will be the definitive factor. However, the courts are required to look at the best interest of the child. In Florida, we're always after the best interest of our kids. And so it becomes one of the factors. In general, when a child's over 12, the court will begin to put more weight to that factor as far as the ability to listen to them. Not the ability, but the weightiness of what they will place on that factor, as far as a 16-year-old who's saying, I want to live with the other parent, can make life miserable for those around, and they may say, I'm going to run away. There's a lot of things that the older kids may say, and so the court doesn't want that to happen. We want to try to work. So the court may say, well, we need some counseling, we need some other issues. So it is not in Florida a situation where a child can just come in at some age and say, I'm going to go live with the other spouse.